Things to know about an asset hearing in Claremore. An asset hearing in Claremore can be a very serious court proceeding for individuals who owe money on a judgment. Many people are unfamiliar with the term asset hearing until they receive a court order requiring them to appear before a judge and answer questions about their finances, property, income, bank accounts, and assets. These hearings commonly occur after a creditor has already obtained a judgment against a person in Rogers County or elsewhere in Oklahoma. An asset hearing usually happens after a creditor wins a judgment. In Oklahoma, creditors generally cannot request an asset hearing until they first obtain a judgment against the debtor. This means the creditor already sued the individual and received a court judgment establishing the debt. After the judgment is entered, the creditor may begin efforts to locate assets and collect the money owed. One of the tools available under Oklahoma law is a hearing requiring the debtor to appear in court and disclose financial information. The purpose is generally to help the creditor identify income, bank accounts, vehicles, real estate, or other assets that may potentially be used to satisfy the judgment. You may be required to testify about your finances. At an asset hearing, the debtor may be placed under oath and questioned regarding financial matters. The creditor's attorney may ask about employment and wages, bank accounts, vehicles, real estate, business ownership, cash assets, retirement accounts, property transfers, and other valuable assets. The hearing is designed to help the creditor determine whether collectible assets exist and what collection remedies may be available. Because testimony is given under oath, honesty is extremely important during the proceeding. Creditors may use the information to pursue collection efforts. One of the most important things to understand about an asset hearing in Claremore is that the information obtained may later be used to pursue collection activity. Depending on the circumstances, creditors may later attempt wage garnishments, bank garnishments, judgment liens, execution on non-exempt property, and investigation of transferred assets. However, Oklahoma law also provides important exemptions protecting certain property from collection efforts. Some property may be protected under Oklahoma exemption laws. Many people mistakenly assume creditors can automatically seize everything they own after a judgment. In reality, Oklahoma exemption laws protect certain categories of property from collection. Depending on the situation, protected property may include homestead property, certain wages, retirement accounts, household goods, tools of the trade, and certain personal property. The availability of exemptions often depends on the type of property involved and the specific facts of the case. Because exemption laws can become highly technical, legal guidance is often extremely important during collection proceedings. Failing to appear can create serious problems. If a person receives a valid court order requiring appearance at an asset hearing, failing to appear can create major legal problems. In some situations, the court may issue a bench warrant, hold the individual in contempt, impose sanctions, and schedule additional proceedings. Many people make the mistake of ignoring these hearings because they believe they have no money to pay the judgment. Even if the person lacks assets, appearing in court is still usually extremely important. Asset hearings often involve business owners. Business owners in Claremore frequently face additional complications during asset hearings. Creditors may investigate LLC ownership interests, business bank accounts, accounts receivable, equipment, real estate holdings, and transfers between personal and business accounts. When businesses and personal finances are heavily intertwined, collection proceedings can become significantly more complicated. Bankruptcy may sometimes stop collection proceedings. In some situations, individuals facing aggressive collection efforts, repeated garnishments, or large judgments may explore bankruptcy protection. Filing bankruptcy may trigger the automatic stay, which generally stops many collection actions, including garnishments and supplemental proceedings. However, whether bankruptcy is appropriate depends heavily on the size of the debt, the type of judgment involved, the person's assets, income levels, and other financial obligations. Because bankruptcy and collection law often overlap, careful legal analysis may be necessary before making decisions. Preparation matters before the hearing. Asset hearings can move quickly, and creditors' attorneys are often well prepared with financial records, public filings, and prior court information. Individuals appearing at these hearings should carefully review income information, bank records, property ownership, existing judgments, and prior transfers of assets. Inconsistent statements or incomplete disclosures can create additional legal complications. Why legal representation matters. Many people underestimate how serious post-judgment proceedings can become. Asset hearings may expose financial information that significantly affects future collection activity and property rights. Because Oklahoma collection laws and exemption rules can become highly technical, individuals facing an asset hearing should seek experienced legal guidance as early as possible. Get a free consultation with a Kania Law, Claremore attorneys by calling 918-379-4862.